Hello, my name is Adam White, and I am the president of the Florida Bar Young Lawyers Division Board of Governors. I'm also a practicing attorney with the law firm of Emanuel, Shepherd, and Condon in Pensacola, Florida. For those of you that do not know, lawyers are automatically members of the YLD. They have practiced for less than 5 years or are under the age of 36. The YLD is commonly referred to as the workhorse of the Florida Bar, and we work our hardest to improve the lives of our fellow lawyers. We do this by advocating for, educating, and serving Florida young lawyers. While not within the scope of our normal operations, the recent pandemic and resulting delay in the taking of the Florida bar exam has greatly affected our colleagues who will soon be members of our division. As a result, we've partnered with the Florida Board of Bar Examiners to bring you this webinar today that should help to more thoroughly explain the temporary supervised practice program. To do this, we have with us today James Allman. He has been the general counsel of the Florida Board of Bar Examiners since August 2017. Previously, he was a shareholder with the Kinney Knockwalter law firm in Miami, where he practiced in the firm's antitrust group. We hope today to have time for a short Q&A session at the end of the presentation to answer any further questions that you may have. Thank you for joining us today, and with that, Mr. Allman, the floor is yours.
Thank you for the introduction, Adam, and I thank you and the Young Lawyers Division for setting up this platform to talk more about the Supervised Practice Program. The support that we've received from the Florida Bar has been outstanding and essential to getting this program off the ground. There's been great interest in the program. We approved 63 applications just in the first week. We're going to approve even more than that this week, and we continue to receive new applications. We're answering questions daily from applicants who want to participate, and we hope that applicants will continue to take advantage of the opportunity to participate in the program. We also hope that the program will help aspiring lawyers create rewarding and long-lasting relationships with experienced members of the bar. The purpose of this webinar is to talk about the Supervised Practice Program in more detail. What's the basic concept, what the eligibility requirements are, how to apply, what participants can and can't do, and when it ends. So with that, I'll share my slides. And we'll start with the idea behind the program. In recommending a supervised practice program to the court, we had the benefit of not working completely from scratch. The court certified legal intern program has been in place for some time and offered a model for how to allow some limited practice while protecting the public and safeguarding the judicial system. The supervised practice program essentially extends the certified legal intern program to a broader scope of legal work. Certified legal interns are generally law students who work for government entities, the state attorney's office, the public defender, or legal aid organizations as part of a clinic. The supervised practice program broadens that focus to allow for supervised practice with private attorneys and other fields. As a result, much of the language that's in the Supreme Court's supervised practice order comes straight from Chapter 11 of the rules regulating the Florida Bar, which contains the rules for the certified legal intern program. That was the starting point for building the order. Court entered the supervised practice order on August 24th, and the board started accepting applications the next day. Again, we're pleased to see the interest in the program, and we've heard a lot of positive feedback about it. Turning now to the nuts and bolts of the program. Let's take a look at the requirements for participating. Some of the requirements depend on whether the person is a lawyer who's already admitted to practice and in good standing in another state. But to start, all participants have to meet the requirements that are shown on this slide. First, the board must have issued a ticket for the July 2020 bar exam to the person. The issued a ticket language is important because the program is intended to include people who applied for and received a ticket to the July 2020 bar exam, but decided to postpone. With the pandemic, The board has been flexible about allowing applicants to postpone, including waiving fees associated with postponements, and thought that those who postponed should still have the benefit of the program if they otherwise qualified. Second, all applicants had to have graduated from an ABA accredited law school. Third, all applicants must have received their character and fitness clearance from the board. If you have a question about whether you've been cleared on character and fitness, you should write the board to clarify your status. And last, all applicants also must certify that they've read, understand, and will abide by the rules of professional conduct. Now, applicants who are not admitted to practice and in good standing in another state, and this includes applicants who recently graduated from law school, they have to meet some additional requirements. One is that they have never taken a bar exam before February 1st of 2020. This rule tracks the certified legal intern rules for bar passage. A certified legal intern has to take the first bar exam after graduation. And if the certified legal intern fails that exam, the CLI can keep that status until the next exam. Now, if the certified legal intern doesn't take or fails the second exam, the certified legal intern status is over. Applying that concept to the supervised practice program, as we were putting it together, the program allows applicants to participate if they took the bar exam for the first time in February 2020 and didn't pass. Second, applicants who are not admitted and in good standing in another state must have a passing MPRE score. And note that for the limited purpose of this program, the passing MPRE score does not have to be within 25 months of when you apply. A passing MPRE score at any time is sufficient for participation in the temporary supervised practice program. Now, on the application, you'll see that you're asked to provide the date when you took the MPRE. We ask for that only because it helps our staff confirm your passing score faster. We'll also need the standard dean certificate from your law school. If you aren't sure whether we've received a dean certificate for you, please write. This is part and parcel of any bar application. The lawyers who are in good standing and admitted to practice in another U.S. jurisdiction don't need to provide an MPRE score, and they don't need to provide a dean certificate. Instead, the additional requirements are that the lawyer not be subject to disciplinary proceedings in the other jurisdiction or jurisdictions where they are admitted, and that these lawyers agree to submit to the jurisdiction of the Florida Supreme Court for disciplinary purposes. Now that we've covered who's eligible, let's talk about how to apply. Much like the certified legal intern application, the application for this program is very easy. We've created two forms, 1 page apiece, one for the applicant, one for a supervising attorney. Both of them are available on the board's website. You can upload the forms via your applicant portal. For those applicants who don't have a portal account, which at this point is a small minority of applicants, we also accept them via US mail and fax. Once we receive your application, we will send you a letter acknowledging receipt. That first letter does not authorize you to start supervised practice. All it does is let you know that we've received the application and we're checking it against your file. We send certifications to the court weekly on this. If you are approved, you'll get a separate approval letter. And once you receive that separate letter, you can start supervised practice. So this is the application, this 1 page. What you're asked to certify is that you meet the various eligibility requirements. And everything that's on here comes straight from the court's order. You'll see that some of the paragraphs are written in the alternative. That accounts for the fact that we were talking before that some of the requirements depend on whether you're already admitted to practice law and in good standing in another state. There are also basic eligibility requirements for supervising attorneys. Supervisors must be members of the Florida Bar in good standing who are eligible to practice law and have had that status for at least 5 years. So that means that inactive members can't be supervisors. It also means that attorneys can't be supervisors if they've had suspensions or lapses in membership within the last 5 years. They also can't have any pending discipline. One question that we've received at the board is whether someone can have multiple supervisors, all of whom will have less than 5 years experience, and then aggregate their experience to get to the 5-year mark. While it's okay to have multiple supervisors, and we'll talk more about that, it's not okay to add their experience together to meet the 5-year threshold. The order's clear that each supervisor needs to meet the 5-year experience requirement. So this is the supervisor's form. Again, it's 1 page, and this form should be submitted with the application. Here, what we're asking for is your name, your file number, and then we want the supervisor's name, bar number, date of admission, and contact information. That's what we need to be able to confirm that your supervising attorney has been admitted for at least 5 years and meets the other basic requirements to be a supervising attorney under the order. And next we turn to the responsibilities that a supervisor is expected to accept. Most importantly, the supervisor is professionally responsible for all of the services that a participant provides and the quality of the participant's work. We've been asked in the last week about how this program affects malpractice insurance. Of course, we can't speak for insurance companies and particular insurance relationships, but that's a conversation that your supervising attorney may need to have with the carrier, because the supervising attorney is taking on responsibility for the participant's work. Supervisors also have to enter an appearance in every matter in which the supervised practice participant appears. The supervisor also has to sign pleadings and court filings, even if they were prepared by the participant. In cases involving court-appointed counsel, the supervisor has to be present and must also be present if the court requires the supervisor's presence at a proceeding. Now, in terms of the presence requirement, the court has allowed for some flexibility. Presence does not necessarily mean physical presence, which is consistent with how the court has adapted to changes in the practice of law during the pandemic. Presence through Zoom or another audiovisual platform is sufficient. Now, the court's order does add, though, that if the supervisor is going to be present through Zoom or some other type of audio video, there needs to be a separate confidential line of communication between the supervisor and the participant during the proceeding so that the supervisor is able to help. Also, we've been asked about whether a participant can have more than one supervisor, because that may make it easier for, say, a law firm to comply with the requirement that a supervisor be present. The answer to that question is yes, you can have multiple supervisors as long as they agree to accept the responsibilities of a supervising attorney, and as long as we get a form for each supervisor to confirm that each person meets the eligibility requirements. You can submit multiple supervisor forms with the same application for temporary supervised practice. Now let's turn now to what the supervised practice order allows a participant to do. The participant can appear in any Florida court, administrative tribunal, or ADR form. The extent of the participation is up to the court or the tribunal in the matter, and the court can require the supervisor to be present at any time. The participant can appear, though, only if there's written consent from the supervisor and also the client or the government agency that the participant is representing. Those consents need to be filed in every matter in which the participant appears per the court's order. Participants can also draft legal documents, and they can do that outside of the supervisor's presence. So there we're talking about pleadings, briefs, court filings. But remember, the supervisor has to sign the documents that get filed in court. But we're also talking about transactional documents, contracts, wills, and also applications for post-conviction relief are something that a participant can draft outside of the supervisor's presence. Turning now to compensation issues and some things that participants can't do under the order. So first, supervised practice participants need to be employed by the supervising attorney or the same entity that employs the supervising attorney. A participant can't work at one law firm and then have a supervisor at another law firm. Now, we've been asked if a participant with a job at an in-house corporate legal department can be in the program. The answer is yes, as long as the supervisor is working for the same company and meets the requirements for being a supervising attorney. There are also rules about what a participant can't do with respect to compensation. A participant can't ask for or receive compensation directly from the client. They can't negotiate a fee agreement. They can't open their own law practice. Now, on this point about receiving compensation directly from a client, a supervising attorney or law firm can charge the client for the participant's services. That's in the order. We received a question about whether a participant's time may be included on a bill to a client that's sent by the supervisor or the law firm. And yes, it can. But of course, the client should be informed that the participant is not a fully admitted lawyer. Now, supervised practice is a privilege, and it can be terminated. The court has reserved the right to terminate the privilege at any time. The court's order also gives the board the authority to revoke its character and fitness clearance if there's some new potentially disqualifying conduct. Participants are not members of the Florida Bar, so they're still subject to the Florida Board of Bar Examiners jurisdiction, which means that they have to keep their bar application current and correct by amending it within 30 days of any event that would change an answer on their bar application. Likewise, the dean is authorized to revoke the dean's certificate, which then may trigger a reconsideration of the approval to participate. Now, note one thing that will not end the ability to participate in the supervised practice program. If you don't take or don't pass the October bar exam, you can continue to participate in the program. We believe this is consistent with the provision in the certified legal intern rules that allows those interns to retain their status regardless of the results of the first bar exam after graduation. However, the entire program automatically terminates 30 days after results are released for the February 2021 exam, which usually happens in mid-April. At that point, participants will have had 2 opportunities to pass the bar exam, and the 30 days gives those who are unsuccessful an opportunity to transition from supervised practice. So beyond what we can answer in our short time today, the board has resources and lines of communication that are open to you. We have a section of our frequently asked questions on our website that's devoted specifically to the supervised practice program. We encourage you to check those FAQs before writing us, but we understand that you may have questions about how to participate the right way in this program that go beyond the FAQs. We're happy to answer them. Applicants with a portal account should send us those questions through their applicant portal. Applicants who don't have a portal account should send the questions to the email address on this slide, support@floridabarexam.org. So I hope that this information has been helpful to you. In the time we have left, we can try to field some more questions. And in the event that we can't answer a question for you today, please follow up with the board in writing and we'll get you a prompt response. So with that, I'll turn it back over to Adam.
Thank you, Mr. Allman. First, before we start delving into the questions, Mr. Allman, can you stop sharing your screen so I can share a website? Earlier today, the people attending this webinar may have noticed that the Young Lawyers Division launched a website, the idea being that we could assist these applicants match with supervising attorneys. I'm going to share my screen for that website briefly so that you can see it. And you can see the address for the website is flayld.org/supervise-practice-program/. And this website houses all the information related to the supervised practice program, including the necessary forms, as well as links to the FBBE website. We're also going to include a recording of this webinar. And down towards the bottom of the website, you will see that we have a place for potential supervising attorneys to register, indicating that they are available and willing to supervise applicants, as well as their location and practice area. So we hope to have additional attorneys sign up for that program in the very near future. Jumping, Mr. Allman, to the questions today, I'm just going to go through them as they've been asked throughout the webinar. First question is there any way to apply for a waiver to the rule about having not taken a bar exam prior to February 2020 if the applicant passed the Florida portion prior to February 2020?
You'll have to write us on that one. I will say, though, that this thought about extending eligibility out to allow people who didn't pass in February was something that was heavily discussed in terms of what the eligibility would be. And I don't know how much appetite there is to revisit that decision, but that was a decision that was considered by the board and discussed with the bar, and the court's aware of it too.
Okay. Next question is, what if the proposed supervisor was licensed in another jurisdiction previously greater than 5 years, but has been licensed in Florida for less than 5 years?
We're not, to my knowledge, that there's no flexibility on the 5-year requirement in terms of somebody having been a member in good standing of the Florida bar for 5 years.
Another issue that's come up, I know that I've been asked personally, and I think we've got about 3 questions on this so far in the webinar, is for the applicant, whenever documents are being filed with the court, what is the appropriate designation to add to that applicant's name in that filing, or should that applicant's name even be indicated in the filing?
Okay, so we can answer both of these, and I'm glad these questions were asked because they've come up and there just wasn't really a good place to fit them in the slideshow. So first, in terms of what you can call yourself, the easiest thing to do is to use the term that the court came up with, which is supervised practice participant. It's a term of art that the court put into the order. I understand that some people may not want to use that term because it may be difficult to communicate what that means to people who aren't lawyers and aren't familiar with the program. And to that, I say there's some flexibility in terms of what you call yourself. Adam, I believe in one of the questions that was up here, there was an example of what somebody wanted to say, like, temporarily admitted pursuant to a certain court order, right? Or, I mean, so you can, there's some creativity in terms of what you say, but the main thing is you cannot hold yourself out as a lawyer. Okay, so don't call yourself an attorney, don't call yourself a lawyer, don't use Esquire. Okay, I mean, even associates in a law firm suggest that you're a lawyer. you should, if you're going to use another term besides supervised practice participant, it should be very clear and correct to others that you are not a member of the Florida Bar.
And by way of example, I think the phrase that you're referring to was attorney authorized to engage in supervised practice under that administrative order. And just to be clear, it would be improper to say attorney authorized. It would need to be something similar to
I would just say authorized without the word attorney. Right.
Next question is, they've already been approved for supervised practice with one supervising attorney. And they've asked that when they submit additional supervising attorneys forms in support, do they need to wait for approval for each supervising attorney?
Well, if you've been approved, you're approved to engage in supervised practice with that supervisor. So if you want to add supervisors, you can write in and we can add supervisors, to our log to show who you can work with. So for now, this person is able to engage in supervised practice, being supervised by the person whom we've approved. And then as we issue you more approvals, to say that these other people can be your supervisors also, and once you receive letters of approval for that, then you can start working for those other people as well.
Another question that we've gotten multiple times is, it's kind of twofold. Are the supervising attorneys required to pay these applicants? And also the question of, are they allowed to be paid by the employer?
So yes, they are allowed to be paid by the employer. That's specifically allowed in the order. Okay. And in terms of whether they have to be paid, the order doesn't address that. So if that's the arrangement that somebody works out with the supervisor, then we're not going to get in the middle of that.
Okay. I believe you answered this at the beginning of the webinar, but somebody asked a question about having trouble finding where they can submit the application forms through the FBBE. So where's the best way to submit those forms and to find them?
I predate the applicant portal, so I've never actually used it myself. But it would be the same way that you would submit any other correspondence via the applicant portal. That you would submit the form. And if for some reason you're having trouble with the applicant portal, there is the email address, there's mail, there's fax. But if you've gotten to this point in the process, I'm sure you've used the applicant portal at some point to send us bar application amendments, send us other correspondence. It would be the same process for that.
Okay. Another question we've gotten is that this person is a solo practitioner and they plan to supervise an applicant. And there's also other solo practitioners that they're working with that plan on supervising the same participant. Do each of those solos have to apply to be a supervisor for the participant?
Everyone who is going to be a supervisor needs to fill out a supervisor form. We have to confirm that each supervisor meets the requirements of the program.
Okay. Next question is, as far as attendance at hearings, what is the supervising attorney's role when they go to a hearing with their applicant?
Well, that's up to, first of all, it's up to the court, right? It's up to the judge, it's up to the administrative tribunal, the extent to which the supervised practice participant can speak in court and otherwise participate. And then after that level, it's between the supervising attorney and the participant to see how much the supervisor will let you do.
Okay. After the applicant is approved, are they allowed to give legal advice directly to a client of their employer?
Yes, they can do that. Again, this is under supervision, and the client should know what your status is when you're giving them that advice.
Next question is, how long generally, I know you indicated there were over 60 applications that have already been approved. Do you know how long generally it's taking to get those applications approved right now?
Not very long at all. As I mentioned, we turned around 63 applications just in the first couple of days of the program, really. And we've got even more to do this week. The application is very straightforward for us to be able to check it against our files and our databases to make sure that you meet all of the criteria for participating in the program. We send a certification over to the court every week saying these are the people who we've approved, and that's kind of the moment that would then cause us to send you the letter that says that you're approved. So if you send something, it should not take very long at all to turn around your application, assuming that you've met everything.
Okay. The next question is whether or not there are any fees associated with this application process.
There are not.
Okay. Well, I know we covered hearings as far as who's permitted to do what at hearings being based on what the judge allows and what the supervising attorney allows. What about for depositions?
With depositions, unless the court is requiring that the supervising attorney be there, you can take a deposition without the presence of the supervisor. Again, that's something you're going to have to work out with your supervisor to see if they'll let you do that. But if they do, and the court is not requiring that the supervisor be there, that's not like a critical stage in the proceedings, for example. In a criminal case, the way that that the order specifically requires somebody to be there. So in that case, yes, you can take the deposition.
Okay. Will applicants that participate in this program be given a designated number from FBBE?
We're just using the applicant's file number with FBBE for this. There's no new number.
Okay.
And I want to go back to an earlier question about what I believe in the question that you had asked about what supervised practice participants can call themselves. I think part of that question also was what they call themselves on the signature block. What was that? I think that might have been part of it. And in that case, we're not micromanaging what goes on the signature block, other than to say that the supervising attorney has to sign the document. Now, what this contemplates is that a supervised practice participant is going to enter an appearance in the case, right, with the required consent, so that everybody in the case is going to know that you are in fact a supervised practice participant. So putting something in the signature block that has the supervising attorney's name and then the participant's name afterwards, would be fine, right? And it would be fine also to include perhaps a little asterisk with a disclosure to say that, you're a supervised practice participant or admitted pursuant to this order, or whatever language that accurately communicates your status.
Okay. The next question is it the applicant who is responsible for submitting the supervised practice participant application and the supervisor's application together in one package?
Yes, the applicant submits it all together in one package.
Okay. Sorry, I'm trying to roll through these.
Fire away. I think we're doing pretty well.
Just answered that one. If the character and fitness clearance is the only requirement not met for the program, is there any way to expedite that character and fitness process?
Well, we actually have expedited the approval of a lot of files over the last couple of weeks to make sure that everybody who could be expedited is approved. So we're doing our best to move through those files. You can always write us and ask for the status of your file if you're unsure about that. But if your file has not been pending for very long, we may tell you that you're not even at the normal time that it usually takes to process an application.
Okay. I got another question about terminology. They've indicated whether or not the term incoming associate or associate, admitted to temporarily practice under supervision would be proper terminology.
Having not spoken with the bar about that, associate gives me a bit of heartburn, and I don't think that would be a good one. I noticed that in the queue here, there's another question for authorized to engage in supervised practice pursuant to the Supreme Court of Florida. That would be a good one. Another one that I've heard that I think is acceptable is JD 2020 pending admission. We've heard some creative but accurate ways to represent the status. And if you're unsure about a specific wording, email it to us or send it through your applicant portal, and we'll get you an answer on it.
Another interesting question is whether or not for clients, for private practice or for criminal cases or civil cases, do they need client approval to be on that client's case, to work
Yes.
on that client's case?
Yes, they do.
If a participant isn't appearing, does the supervising attorney need to file an appearance in the case?
No, the supervising attorney only needs to appear if the participant is appearing.
Would the participant in the program be signing any pleadings or motions that are filed?
The participant would, the supervising attorney would.
Is there any requirement in the administrative order that the client consent in writing to the participant participating in their case?
Yes, there is. And that client consent needs to be filed in the matter.
So I'm just going back through the questions. Okay, this is a specific question. When you state that these temporary practice program participants do not necessarily need to be compensated, that is just related to the bar requirements, not IRS or other federal or state law requirements, correct?
That's correct. We're not opining on any of that other stuff. This is just about what's required in the court's order.
Next question is, does a state agency have to consent to a participant appearing in a hearing, I assume, before that state agency?
If we're talking about some sort of administrative proceeding, the court's order speaks to that and says that the practice participant can participate in the hearing or administrative proceeding to the extent that the tribunal lets them do that.
Okay. Outside of litigation, the question is, as far as working for corporate clients not involved in any court matters, would a consent on file at the attorney's office suffice?
Yes, I mean, if there's no court matters, that the participant's working in, there's nothing to file it in. So having that written consent on file is good enough.
Okay. Can the participant work on files for other attorneys in the firm who are not their supervisor if they do not appear?
Well, that's the question's a little vague in that it's unclear what working on files. I'm not exactly sure what it is you're doing and whether you're working under the general supervision of your supervisor, even if you're working with another attorney. So, for example, if you're drafting a pleading for another attorney, that can be done outside of the general supervision of your outside of the presence of your supervisor. And so if you're writing a pleading for another attorney in the firm, but your supervisor still is okay with that and they're vouching for the quality of your work, I could see how that could still work. The easiest thing to do, if the person qualifies, would be to send in another supervisor's form.
Okay.
Right.
The next question is, if the participant already qualifies under the CLI for a state agency, such as a state attorney's office, can they work under CLI rather than the supervised practice?
Yes.
Next question is, can they add a written consent in their engagement letter with a client, or do they need to separate consent? Do they need a separate consent document?
Well, given that you're gonna have to file the consent in the matter, I would think that you probably want just a separate, simple document reflecting the consent without necessarily having to file the entire engagement letter in court.
Okay. And the next question was, is the court going to be creating any sort of consent form that complies with the rules?
Not to my knowledge. So you just need to write something simple that reflects the consent, and I could see a notice of filing or something in the docket that would take care of it.
Okay. Next question is, who is the client that would need to sign a written consent for a supervised practice participant's appearance, for instance, in a third-party insurance matter where that insurance company retained the law firm?
without knowing more, it's difficult to answer that question. But whoever
Right.
the client is who, yeah, all I can say is whoever the client is needs to file the consent.
Yeah, I
And
would think.
maybe in that case, it may be best to get it from both.
Right. Understood. I think what they're indicating here would be the tripartite relationship where it's an insurance company who retains the firm on behalf of the insured, like in a liability matter. So I think what we're indicating is the safest bet at that point would you get both the direct insured and the insurance company to consent to the relationship.
Yes, I mean, and I don't want to get too far out over my skis on this, but I think that seems like the safest approach.
The next question that we have is how would the disciplinary process work for against a participant?
Well, you're still subject to the jurisdiction of the Florida Board of Bar Examiners. So if there is potentially disqualifying conduct, which includes misconduct in employment, that could be a matter that causes us to reconsider your character and fitness pursuant to the normal procedures that we have for investigating and making rulings on character and fitness.
The next question is just a clarification. Do law firms or must law firms receive written consent from clients in any matter the supervised participant works on?
Yes.
Okay. The next question is the required dean certificate already on file with the Board of Bar Examiners from the original bar application, or does the proposed supervised practice participant need to request another certificate from the dean?
It's the same dean certificate that you already got for your bar application. I think for most people, we already have it.
Okay. All right, this was something that I know that I've spoken with you about, but it's whether or not a supervising lawyer can be in a corporate role similar to a general counsel, and how that works with the program.
Yes, and we covered that in the presentation also, because this is a question that we've gotten, and both we and the bar read the order as saying that somebody who's in a legal department in a corporation can be a supervising attorney. So as long as the participant and the supervisor are employed by the same corporation or company, that's fine.
Okay. All right. Well, those are all the questions that I've got so far. So just for everybody on this webinar, thank you very much for joining us. The course number for this webinar is course number 4164. You're also going to receive an email at the conclusion of the webinar that will give that course number. In addition, if you will go to the website that we referred to earlier about the Supervised Practice Program, this webinar has been recorded today and it will be posted there. Most likely it will also be posted on other Florida Bar websites. If you have any additional questions, don't hesitate to reach out to the avenues that Mr. Allman gave you today. And again, thank you for joining us.
Adam, do you want to talk about the website?
Yes, so like I said before, and I'll share it one more time to remind everybody, the YLD created a website to provide everything with regard to the Supervised Practice Program. As you will see, it explains the program a little bit. This webinar will also be posted there. We also have the applications to participate in the program on that website, as well as the administrative order concerning the program. And hopefully, starting today and moving on, we'll have people who are supervising attorneys or willing to supervise applicants register on this website, and you'll be able to go to the website and search both by geographical location and practice area to find an attorney that will hopefully allow you to participate in that program.
Okay, great. Adam, thanks so much for putting this together. We appreciate the opportunity to get more information out about this program and hope that more people take advantage of it.
All right, thank you. And I hope you have a good day, everybody.